Welcome to the Florida Divorce Podcast, your source for the information you need to successfully get through your divorce and into the next exciting chapter of life. Now, here's your host, Attorney Scott Kalish.
Hey everybody, this is Attorney Scott Kalish. I am a divorce and family lawyer here in South Florida. Thanks so much for listening to the Florida Divorce Podcast. Today, I want to go through a subject that is near and dear to my heart, and that's trial. You know, as a young lawyer, when I first graduated from law school, my first job was at the prosecutor's office, at the state attorney's office, actually in the Tampa Bay area in Pinellas County. And everyone knows, you know, if you're a lawyer, everyone knows that if you want the most trial experience as a young attorney out of law school, you either go to the state attorney's office, right, to be a prosecutor, or you go to the public defender's office and be a public defender, because literally from the first week or two on the job, you're literally thrown into full-blown trials, right, criminal trials, you know, very, very early on, like I said before, week one or week two, and you're trying misdemeanor cases, right, criminal misdemeanor cases like trespass, DUI, petty theft, that type of thing. But really, there's not much difference, right? There's really not any difference from trying a misdemeanor case, right, like a DUI, to a felony case. So it's the same procedure, same process. So it's jumping into the deep end, you know, extremely fast, and you get a ton of opportunity to be in court pretty much each and every day, and then to do trials, I would say at least once a week if you really want to. You know, sometimes as a prosecutor, at least, and a public defender, you don't have a full say over whether or not a trial actually proceeds to trial or if it resolves, right? If there's an agreement reached right before trial. So, you know, I can tell you, I was a prosecutor for 3 years and I did dozens of trials. And then I would say that I prepared many more than that to go to trial, and then they would resolve or maybe not show up. You know, the defendant would not show up some of the times to the actual trial date. And then obviously we couldn't do the trial without the defendant there. But yeah, many trials. So that was my first job. And, you know, at the state attorney's office, I really fell in love with trial. And that's why it's, you know, definitely near and dear to my heart, something that I really enjoy doing. I can tell you that as a lawyer, that's probably the best part of my job, right? Is when I'm actually in court doing a trial. One of the least favorite things that I have is preparing a trial, you know, quite surprisingly, right? It's like a double-edged sword, right? Preparing for trial is never fun. And it for most lawyers, it's not fun. It's a lot of work and, you know, a lot of detailed, meticulous sort of review of the case, you know, the facts, just making sure everything is in order. And it's just a very, very tedious process, and sometimes a lonely process, you know, because, you know, you're preparing the case for trial. You're not really interacting with people. Some of the time you are, some of the time you're, you know, talking to your witnesses and making sure the testimony is in order. But for the most part, it's not fun, but it's definitely a 180 when trial starts and you get into it. So today I want to talk to you guys about the trial process. I want to give you a sense of what trial is and what it costs, whether or not you should go to trial, what it looks like, so that when you start your case, or if you've already started your divorce case and you hear the word trial, you have some more information about it, right? And you can better sort of, you know, picture what to expect and what's at trial. So let's go through, I mean, just before I actually get into the specifics of trial, right? Let me give you a frame of reference. I would say, you know, the vast majority of divorce cases settle before they get to trial, right? Most cases settle at mediation, and there's a select few that, you know, for one reason or the other, they don't settle, and a judge is required to step in and make the decision. But like I said before, most cases do settle, and they do so either at mediation or before or after mediation, right? You know, kind of behind the scenes. Sometimes I have cases where we don't even need to go to mediation because the parties, you know, are on the same page, and we do the agreements, the parenting plan if there are children, and a marital settlement agreement, right, before mediation takes place. Other times it takes mediation, right? It takes everybody getting into the same room to hammer out a deal to resolve the case. Other times we go to mediation and we're almost there, and the attorneys end up working after mediation in the days and weeks after mediation, and they're able to come to an agreement sort of behind the scenes. Sometimes it takes cases, multiple mediations to settle, right? Sometimes there's, 2 or even perhaps 3 mediations before a case can resolve. But in those cases where the parties cannot bridge the gap on their disagreements, a judge will have to step in and make the ultimate decision, right? And a lot of lawyers tell clients, myself included, right? When you go to trial, you definitely lose control. A judge at that point is the one that makes the decision. And most people are uncomfortable with a stranger listening to both sides and making a decision, right? Because ultimately, at the end of the day, a judge is a person too, right? They're a lawyer. Sometimes they're not a very experienced family lawyer, right? Sometimes judges are in one area of the courthouse. Sometimes they're criminal judges for years and years and years. And then all of a sudden, the chief judge assigns them to the family division. And if you're unlucky enough to get a judge that's brand new on the family bench, it can be scary because, family law, despite what some lawyers say, it's definitely a complicated, complex area, and it's nuanced and it can be learned. It's not the most complex area of law out there, but it's definitely not simple or straightforward. So sometimes putting the fate of your family, fate of your finances into someone, a person, right, even if they're a lawyer, into their hands that don't have the experience on the family bench, it can be scary. And sometimes it's just not the right move because, there are appellate judges, right? So if your case goes to trial and the judge makes an error of law or makes an error, like an abuse of discretion, they call it, right? When they hear the facts and it's just totally backwards. And, if their decision is totally backwards, then we have judges that you can appeal to, right? You can appeal your case to a higher court where they, hear what happened at trial and look at the judge's decision. And at that point they can reverse it or they can affirm, what was decided. But that's a long process. It costs, a decent amount of money to do that. And sometimes that's a crapshoot because sometimes they, the higher court will review the case, review what happened, right? Review the lower judge's decision, review the trial court's decision, and then just say affirmed without giving a reason, right? That's called a per curiam affirmed. So other times they write out very detailed analysis of their reasoning when they're either affirming or reversing a trial court's decision, but that's not the case all of the time. So, you can't really count on an appeal going through this process. So that's why making sure that you definitely need to go to trial is really critical before you just, deciding that you're going to, take the leap of faith and go to trial. So with that, let me get into kind of what trial actually looks like in a divorce case. So unlike other areas of law, right? So unlike some civil cases or most civil cases in criminal cases, a judge is the trier of fact, right? They decide what happens, right? In a criminal case, and in most civil cases, you have a jury, right? Of your peers, either 6 or 12 jurors, depending upon what type of case it is. And jurors are, members of the public, right? They get summoned for jury duty, and they're the ones that, hear what's going on, and they're the ones that make the decision, right, as to what happens in your case. In family and divorce cases, we don't have a jury. We have a judge. So it's one person, right? So in a jury system, they all have to come to an agreement on what happened. In family and divorce, it's one person, it's the judge. So that's different, right? But at trial, here's kind of, how it goes, right? So let's talk first about evidence, right? So at trial, both lawyers submit their evidence, and evidence can be physical. Evidence can be testimony through witnesses. And we're going to talk about witness testimony in a second, but physical evidence can be, anything that you can really, bring to court and put before the judge, put before the trier of fact. Think of photos, text messages, emails, documents, contracts, bank statements, credit card statements, deeds to real property, charts, summaries, things like that, right? Videos, audio, really anything tangible or anything that you can sense, right, so that you can hear, that can be put in front of the judge to prove or disprove a point of contention, right, something that you guys disagree with. Trial, though, starts off with what's called opening statements, and that's each side's opportunity to really give the judge a preview of what they're going to hear, right? So in criminal law, the rules are very strict that opening statements are not argument, right? You're not supposed to argue your case in opening statements. You're just supposed to give the jury, in a criminal case, a preview of the facts. What does each side expect to present to the jury, right? And what do they expect you to hear from the other side, right? In family, though, the lines are blurred because you don't have a jury, you have a judge. And I would say the rules of procedure, the rules of evidence are a little bit more relaxed with a judge than a jury, because a jury, if they're tainted, right, if they hear the wrong thing, then the whole process stops and it has to start all over again with the new jury. So it's a very delicate process in the criminal world, even in the civil world, to some extent. But in family and divorce, I've heard it being described as, kangaroo court, meaning, kind of anything goes, right? And that's really, in my experience, how it is, because I have, I can kind of compare it to my experience in the criminal world. And family is definitely, more loose, and, things come out in trial that they wouldn't otherwise come out if we had a jury. So opening statements in a divorce case are more argument, in my experience, than a preview of the facts. So it's almost like a opening argument rather than an opening statement, but that's how it starts, right? So each side is given, a brief opportunity, a few minutes, up to, I would say, 10, 15 minutes, sometimes it's as short as a couple minutes, of just to tell the judge what they expect to hear. Once that is over, the next step is the person that filed the case, right, the petitioner, they're given the first opportunity to present their evidence, right? And what they do is they usually start off by calling witnesses, right? And sometimes it's the party, right? So if the petitioner is the wife, they would call the wife sometimes, first, or sometimes they would call the husband, or sometimes they would call another witness, maybe, a forensic accountant, like an expert, maybe a babysitter, a nanny, a teacher. It's strategic who you call first. Putting together your witness list and the witness order is definitely strategic. And, it's something that you would speak to your lawyer about. But that's what happens initially, right? And then through the witnesses, that's when exhibits come into evidence, right? So that's when the evidence that I was talking about before, photos, text messages, emails, those physical items, they would come into evidence through witnesses. You would call, your witness, and let's say it's your, you get called, the wife or the husband, right, gets called, and you have a series of text messages. You would ask the witness, the party, if they recognize the text messages, ask them how they recognize them. You ask, what they are, what they say, and then after laying the proper foundation, right? So there's a whole aspect of trial called the rules of evidence, right? And the rules of evidence tell us that there has to be foundation that has to be laid before exhibits come in, and there's a whole litany of rules, of evidence that have to be complied with before evidence can be entered into and shown to the judge. So that's how that works. Something else that I'll describe that's witness related is that the party that calls the witness, right, they ask questions. And that series of questioning is called direct examination. And that's when the lawyer calling the witness, asks very open-ended questions and expects a response from the witness. And the other party, right, the other side, the opposing side, can ask or can object, right, to certain questions that are being answered. And usually those objections are based off of the rules of evidence again. And the judge, when he or she hears an objection, they will decide and make a legal decision, right, as to whether or not the witness can answer the question. So to give you an example of a question that can be objected to, right, is, in a family case, a big issue is that typically child hearsay, right? Any statements made by a child cannot be admitted into evidence. So that's a big no-no. So if you're on the witness stand, right, and you're asked by the lawyer, what did your child say about X, Y, and Z? You can better believe that there's going to be an objection from the other side, from the other lawyer, as to hearsay, right? It's an out-of-court statement offered for the truth of the matter asserted, right? That's what hearsay is defined as. And what hearsay really is an out-of-court statement. And there's some legal distinctions or there's some legal aspects of it, right, where a statement can technically come in, not as hearsay, but that's way too technical for this episode in this podcast. But just know that hey, the other lawyer can make objections when a lawyer is asking a witness questions. Once those series of questions is done, once that series of questions is completed, is done, the other lawyer, right, has a chance to question the witness themselves, and that's called cross-examination. And the whole purpose of cross-examination is to try and discredit, right, what the witness said, right? So if the questioning on direct examination initially was meant to like build up a point, right, to maybe to describe how bad the other parent is, cross-examination is to try and poke holes in what they said or try and discredit, right, make the witness like not credible. So cross-examination is probably, when I was at the state attorney's office, I didn't do much cross-examination just because there wasn't a lot of opportunities to do it in criminal cases, because the defendant in a criminal case doesn't have to testify, right? They're not really, called as witnesses often. So, and usually the defense, they don't have many witnesses, right? Just by the nature of the dynamic of the case, right? In a criminal case, the state attorney's office, the prosecutor, the state has the burden of proof. They have to prove their case. The defense doesn't have to disprove that they didn't do it. But some people obviously will put on a defense, but it's not super common, right? It happens sometimes. So at the state attorney's office, I really didn't get a chance to do cross-examination as much as I'd like to. But now doing family cases, I do it in every trial, and it's amazing. It's very fun. And it's probably one of my most favorite aspects now of trial is it's because you're able to think on your feet. And if a witness really puts their foot in their mouth and stretches, it's so easy to discredit them and call out like where they're exaggerating or where they're lying. And it's a lot of fun to have those moments where you're just beating up on a witness on cross-examination, so I love it. And that's a, definitely an important part of litigating a case, right? And trying a case. So that's cross-examination. So once all of the witnesses have been called, the next step, the final step, is closing argument. Now, as you can imagine, in a criminal case, this is, and you kind of see this on movies, in movies and TV, where the lawyers are making their closing arguments to the jury, in a lot of these high profile cases like, the Johnny Depp Amber Heard case and, just some of these more controversial cases. You see, these are the clips that you kind of see on TV, right, of the lawyers making their final arguments to the jury. And that happens in family cases too, where we're able to make these arguments to the judge and argue to the judge why or why not they should find a certain way. And I would say most judges allow closing argument. There are some judges that don't want to hear it. They've made up their mind, so they don't want to waste time and they don't want to, hear from both lawyers. But I would say most judges allow it, and most judges will listen to the arguments intently. And sometimes, if it's a close case, a judge won't really know how they're going to rule, or they're on the fence. And closing arguments for that reason can be critical, because you can really zone in on the facts and argue exactly why the judge should find a certain way or maybe not find a certain way, right? So I would say the most important part of closing arguments is to typically the cases, it's very fact driven, right? So you always want to argue the facts, focus on the facts, because the facts, that's what matters in the case. So that's kind of like a 20,000 foot view of what trial is like, right? So just to kind of recap, opening statements, you call witnesses, you're able to do your direct examination of those witnesses, cross-examination of the witnesses, and then closing arguments. And you might ask, how long does trial typically take? And that's, a question that I get asked once we're about ready to go to trial. And it depends. And it depends upon what issues have to be resolved. If you have 15 witnesses on both sides, then trial's definitely lasting over a day. If you're just calling both parties, the husband and wife, and the issues are pretty straightforward and not complex, and there's not a ton of testimony that has to be, elicited from each person, then maybe a half day is okay. If it's if you have a few witnesses on each side, there's a chance that you're able to do it, in one full day, right? And it just depends. It just depends upon the issues and the amount of witnesses, the amount of evidence that each lawyer wants to submit. Then we get to the cost, right? So almost every lawyer will tell you that trial is very expensive. And it's true. Trial is very expensive. And that's because I would say most family lawyers charge by the hour. And trial is typically, traditionally, it's in most cases, it's something that's going to take at least a day. And in some cases, like I said before, it'll take a half day, but most cases it's going to take a day to resolve all of the issues. And most lawyers charge, like I said before, charge by the hour. So just kind of, let's say trial is 6 hours, taking into consideration lunch and maybe a morning docket that the court might have. Let's say, so our hourly rate is right now, it's between $3 and $3.50 an hour. So let's just do 6 times $3.50. That's $2,000 for trial. Now, there is a rule of thumb that most lawyers abide by, and that's for every hour that you're in court, it usually takes about 2 hours of prep time, right? So if we take that into consideration, that's 12 hours of prep plus 6 hours of trial. That's 18 hours times $3.50. That's $6,300 for a 6-hour trial. So almost $7,000. And that's not including the cost of a court reporter, cost of ordering maybe transcripts, the cost of maybe doing depositions, right? And I'm happy to explain what a deposition is, in another podcast episode, but there's prep that has to be done, obviously. And I think 2 hours to every 1 hour is a conservative estimate. But like I just said, there can be other things that have to be done, depending upon what you're going to trial over, right? What issues you're going to trial over. So that's a little bit about the cost. The final point or final topic that I want to talk about is, should you do it, right? Should you go to trial? And for that question, I would say the answer to that question really depends upon the person that has to answer the question, right? If that's you have to do first off, a cost benefit analysis. If the issues are financially driven in your case, and let's say you guys are apart $10,000, and I just did the calculation, it's going to cost, let's say, $6,300 conservatively, maybe up to $10,000 for a more liberal estimate. Most people would say, no, it's not worth it, right? Because it's not worth paying the lawyer almost $10,000 to gain $10,000. And I agree with that. I'm not a big fan of going to trial based on principle, right? I think it's just not wise, right? And it's not a wise investment of money and time and energy, right? And emotion. It's emotional to go to trial. It's not something for the faint of heart, right? It's you're putting your spouse on the witness stand, and you're cross-examining them, and you're making arguments to the court as to why they're not credible, and you're not really promoting, I think, especially if you have kids, or you're not starting off the next phase of your life, right, on a nice note. And I'll say sometimes, though, it's already messed up enough where that really doesn't matter, right? Because the parties are so entrenched and there's so much bad blood already, and it's really not a consideration. But if it is relatively amicable and it's not a big amount that your guys are apart, I would say compromise is better than throwing what's called good money after bad, right? Investing the exact same amount of money that you would otherwise get at trial. So I'm not a huge fan of going to trial on principle, but I have before, just based on clients just, not willing to settle. On the other hand, though, if there's a lot of money involved and we're only talking about a $10,000 investment, then I think it's a great call all day, every day. You just have to make sure that you're on the right side of the facts, obviously, and that the judge is most likely going to rule for you. There are some times where I would say in nearly every case, you never know exactly what's going to happen, how a judge is going to rule. But you definitely want to be on the side of the facts and of the law if you have to make that decision. You definitely don't want to go to trial just to go to trial knowing that you're going to lose. That's just stupid, right? So it's the cost-benefit analysis, right? And it's easy to do the cost-benefit analysis when money is at stake. But in divorces and in other family law cases, sometimes money isn't at stake. Sometimes you have to litigate over a parenting plan. I can tell you that one of the most prolific cases that I've been a part of was a relocation case, right? A parental relocation case where I was representing one parent who did not want the child to go. And then the other parent, wanted to move the child out of state. And it was a long trial. It was a multiple day trial. And, we weren't litigating about money. We were litigating about where this child was going to live the majority of the time and whether or not the other parent was going to be able to move. And in that case, at least to my client would have spent as much money as, they had to keep their kid, living in the same city as them, right? The majority of the time. So in that case, you can't really do a cost benefit analysis. It just has to be based on what personally you want and what you believe is best for your child. So that's, I think, an extreme example. It's something that doesn't happen all of the time in every case. To kind of give you an example on the other side of the spectrum, if let's say one of the only issues that you're having with your spouse is a pickup location, right? And your spouse is adamant that the pickup and drop off location happen at their house. And the other side, you were thinking, hey, no, I want the pickup location to be at a Publix, right? A Publix at whatever intersection that's, not very far from both parties' houses. That issue is not really worth going to trial unless there's like some kind of crazy set of circumstances where, the child cannot be, picked up at either location, right? But like typically those child issues are not really worth trying, not really worth spending thousands of dollars to have both attorneys gear up and put before a judge. So that gives you an idea on both sides of the spectrum. But I would say, trial shouldn't be, you shouldn't be scared of trial. Some lawyers that don't have the experience, are scared of trial and don't like to go to trial. But sometimes those lawyers are great negotiators and great analyzers, right? They're fantastic, very intelligent. So I would say if you have one of those lawyers, sometimes it's going to be very hard to know if you do or not. But if you do, probably not the lawyer that you want to listen to, right? If you about trial, right? So if you find yourself really at the end of the road and you have to make the decision to go to trial or not, and you sense that the lawyer doesn't want to go to trial just because they don't like trial, then I'd suggest maybe changing lawyers. That could be a great lawyer to negotiate and resolve your case, but not the best lawyer to rely on for guidance. And that's really, like I said before, if it's a cost benefit analysis. So if trial is the right decision to make, you want to make sure that you have a lawyer that is not afraid of trial, right? Like I said before, there are people that are scared of trial, and because it's not easy. It's not easy. It's complex, right? With the rules of evidence, rules of procedure, and it's definitely an art and not a science when you're in there. But you have to remember a ton of technical rules. So people are nervous. You have to think on the fly, and you have to remember the rules and objections, and make sure that be strategic and know how what you're presenting, how the order that you're presenting it in. So there's a lot that goes into it. So that's a little bit about should you do it? So this is a particularly long episode. I don't know exactly how long I've been going, but I hope you enjoyed this episode. It's funny. I can talk about this stuff for hours, and maybe I'll have a guest, another trial lawyer on, to kind of talk through, our experiences, trying cases and stuff. But yeah, no, I can talk about this stuff for hours, and I really enjoy this aspect of it. If you have any questions for me about your case, divorce case, trial, let me know. Feel free to email me. My email is scott@kjlawfla.com. Again, scott@kjlawfla.com. If you'd like to get your divorce case started, give us a call, 561-208-1859, or you can send me an email to that email, scott@kjlawfla.com. The first step would be we would coordinate a good time for you to consult with me, and we would see if we're a good fit, whether we're a good fit for you, and whether or not you're a good fit for us. And if so, we'd be happy to represent you. So again, hope you enjoyed this podcast episode on trial. If you'd liked it, can give us a 5-star review on wherever you're listening. We would greatly appreciate it. Have a great one, and look forward to the next episode. Take care.
Thanks for listening to the Florida Divorce Podcast. To learn the 10 secrets behind every successful divorce, visit floridadivorcepodcast.com. If you'd like Scott's help in your divorce case, go to kjlawfla.com.